update, Critical was shut down by the Supreme Court.
In these interrogatories, in our respectful submission, will achieve the objective of narrowing down the issues.
Questions being asked of us that where did the Regional Coalition Center pop up from is all in the law. That is why we are saying that everything is in the law before this court.
All the issues that they are raising here, and if you look at the pleadings, are not in contention.
We accordingly refuse to grant the application and same is accordingly dismissed.
Well, lawyers for NDC 2020 presidential candidate John Dramani Mahama tonight being accused of deliberately delaying the Supreme Court's push to expeditiously hear the matter.
When the court has invited us to come for case trial and management, it means that you have to have your issues before you come to, whether you have an application or not will depend on the ruling that the court gives. But that does not preclude you from coming to court with your issues. And that is exactly what they failed to do.
We have the latest on the 2020 election petition. And top story is always brought to you by Gassim Cement, the Nation Builder. Vodafone, the future is exciting, ready, and Belacqua mineral water. Now, the 2020 NDC presidential candidate John Dramani Mahama's lawyers today pushed to have the EC chairperson Evans Mensah subjected to 12 questions they considered critical. They relate mainly to how the EC managed the elections from results collation to transmission. This was, however, shut down by the Supreme Court following legal resistance from the EC and President Akufo-Addo's own lawyers. Now, this was at day 2 of the 2020 election petition filed by John Mahama, seeking to set aside the results that went in favor of the MPP and Akufo-Addo. Now, court correspondent Joseph Akablay was there and joins me with more. Tell us about these 12 questions.
So I'll run you through some of the questions that were to be asked if the court had granted a request. Question number 5 specifically says, how were the results transmitted from the regional coalition centers to the headquarters of the Electoral Commission? 6 says, did the National Communication Authority facilitate in any way the transmission of results to the headquarters of the Electoral Commission? Then another question that they wanted to ask is, when did Mrs. Evans Mensah, the chairperson of the Electoral Commission, first realized there were errors in figures she had announced in her declaration of results? And so the lawyers attacked the 12 questions and explained why it is necessary. We can take a listen to a bit of the argument. First, Mr. Chikata making the request, the response from the Electoral Commission's lawyer, Justin Amenuvo, and the position of the President's legal team represented by Akoto Ampao.
I refer to the broad scope of discovery because all those orders, further and better particulars, interrogatories, and so on, they are all intended to narrow down the issues for the trial and to make clear what really is in contention between the parties. That is what I wanted to emphasize. So what we have sought in these interrogatories, in our respectful submission, will achieve the objective of narrowing down the issues before this court.
Questions being asked of us that where did the Regional Coalition Center pop up from is all in the law. That is why we are saying that everything is in the law before this court. Now, my lords, we would also realize that the questions posed seek to introduce through the back door new facts which are not anywhere in the petition before this court.
A proposed interrogatory which does not relate to a matter mentioned in paragraph A of sub-rule 1 shall be disallowed, notwithstanding that it might be admissible in cross-examination. So it's a well-established rule of the common law that a matter that may be refused in interrogatories may be allowed during cross-examination. So our position is that all the issues that they are raising here, and if you look at the pleadings, are not in contention. They have been sufficiently answered. There may have been admissions which put them out of contention. And the petitioner may have his occasion during cross-examination to throw some of these questions at the EC.
So those were the arguments, Joseph. Then came the ruling.
Yes, the court said the current rules is operating by has strict timelines. We can take a listen to Chief Justice Enini Yeboah read the decision of the panel.
Was it unanimous, by the way?
Yes.
All seven?
All seven.
Rule 69C4 of the Supreme Court Amendment Rule CI 99 directs the expeditious disposal of the petition and sets timelines for this court to dispose of the petition. It implies that even amendments ought not to be granted, as well as joinder of parties. Subsequent statutory amendments pointed out after 2013 have provided us with new procedural regime and strict timelines. We are strictly bound to comply with CR 90, and therefore we will not apply Order 22 of CR 47 of 2004 in these circumstances. We accordingly refuse to grant the application, and same is accordingly dismissed.
Okay, so this was dismissed, and as you said, there are seven justices sitting on this matter. All of them agreed to dismiss it. Mr. Chachichikete, who brought this forth, representing JM, had concerns with this.
Yes, and so they are supposed to come back tomorrow for case management, but he said the decision of the court, he wants to get a copy of it in order to understand, so that they need to decide what to do next before they can even do the case management. But the president's legal team also equally had issues about how it will drag the process. We can take a listen to Mr. Chikata and lawyer Kotampao.
And if we can have it by the end of the day, that would assist in the further processes that will take. Now, secondly, my Lord, as I indicated right at the beginning, we have served a request to admit facts, which is a request we have served on the first respondent. However, I'm drawing the attention of your lordships to it, because that will also affect whatever other steps are being taken in respect of this case. So I think we recognize that you have just given a ruling about the operation of CI 47 and how it's affected by the subsequent CI, which we will advise ourselves on once we have it. And I think that will guide the process of our recommendations in respect of the case management.
My lords, today was set up for case management. And all lawyers know that case management involves determining the issues for trial. And all of us should have been prepared for that. It is not acceptable that any counsel may suggest that when a date has been fixed for case management, especially in the circumstances of these proceedings where expedition is very paramount, to come to court and make an application that they should be given time to think about the issues.
Okay, so the two sides are obviously disagreeing on what this means going forward. You spoke to the president's own lawyers, represented by Frank Davis. What is his opinion on this?
So he explains further the point that they hold the view that when Mr. Chikata and his team were coming to court to make that application, they should have known that there was the possibility that it will be dismissed or granted. And so either ways, they should have prepared for the business of the day. We can listen.
We heard lawyer for a petitioner talking about time to have certified true copy of the ruling. Well, that is his right, but that will not delay the trial. The courts have indicated quite clearly that tomorrow morning we are here for the pre-trial. Tomorrow morning at 9:30 a.m. we will be here. Indeed, just to let you know that we were ready and prepared with our issues, because the last time the court directed that there was going to be a pre-trial, every lawyer knows that when the case is adjourned for pre-trial or case management, you have to prepare your issues. And if you bring an application to court, you either know that the application will be granted or dismissed. So there is no need to wait for that to happen. Much more so when you filed your application just about 2:40 p.m. yesterday. What did you expect? So yes, the application has been dismissed. Whatever they do afterwards is their own business.
Is your contention that
the real case in court has now started?
Is your contention that they are delaying the process? We heard your colleague make that point that he wanted to be dealt with.
Well, what else could be further from the truth? We came to court when on the 14th. If indeed you wanted an application to be heard, from the 14th that we came to court, we had an intervening period of a Friday. You wait until yesterday before you file the application for interrogatories. And even this morning, that was when they filed the request to produce documents. I mean, what at all can be the reason for that? You can answer. What at all can be the reason for that?
You suspect they are delaying?
I say, what at all can be the reason?
You tell me what you think, sir.
The court said that there should be expedition. The court said there should be expedition. So that answers your question. Okay? When the court has invited us to come for case trial and management, it means that you have to have your issues before you come to court. Whether you have an application or not would depend on the ruling that the court gives. But that does not preclude you from coming to court with your issues. And that is exactly what they failed to do.
I want to bring in now a member of Mr. Mahama's legal team, Eduji Tamaklo. Mr. Tamaklo, thank you for your time here on Top Story.
Evans, good evening. And good evening. Yes.
Great to have you. Let me clarify this. In court today, Mr. Chikota was asking the court to give your side a copy of the ruling. And I had the court say you get it by close of day. It's fair to say we've hit close of day. Do you have it?
As you rightly pointed out, the court gave the assurance that the ruling should be read by, but I can say as we speak, I do not have it because when we finished, if you noticed, the ruling was a written one in the court's record. They now have to basically print it out. I'm confident that first thing tomorrow morning, we should be able to get hold of it.
Also, Mr. Chikota wanted it ahead of tomorrow. And in fact, he wanted Thursday because he wanted to see the judgment, and then that would influence the way you proceed. Now that you don't have it, and yet you're supposed to come in tomorrow, how is that going to affect your approach going forward?
Quite clearly, the orders of the court relative to tomorrow's business is to consider the issue. And the court itself directed that we can have our issues out at the registry of the court before 9:30 when proceedings should be starting. My understanding is that tomorrow we'll go with the issue. What I find a bit curious is the posturing of my learned senior Frank David when the impression is created that the meeting today was examining ABCD. First of all, the date that were given for the motion on the interrogatory for leave was not a date that the petitioner gave himself. This was a date that the registry of the Supreme Court gave. And my understanding is that once you are given a date, a motion, that will be the business for the day. The impression being created that every lawyer should know that at case management you must come with your issue. I do not know which of the rules is my learned senior referring to. Because quite clearly, CI 99, which is governing this process, is a very novel process. Has he practiced under CI 99 before? And so to keep the impression that every lawyer should know that at this case management, you must come with your issue. Why? Has he had conference with someone before? Because the governing legislation on election petition has always been the Supreme Court's rule CI-16. And it has never been the practice that when you come for case management, come with your issues. In fact, in appropriate circumstances, it's at the case management that their lordships are going to give you further direction how they intend to proceed. It is at that point that the court will make orders. For instance, file your witness statements, file your issues, do A, B, C, D. That is what happens. So to go out there and create the impression that every lawyer should know, based on which rule or procedure?
Joining me is
nowhere in the CI 99, which has amended, even if for the purpose of extradition, they did say that the purpose for coming to today was to adopt issues. That was not.
Stay with me. Stay with me, Aduji.
No, Evans, 1 minute. We had a motion. We never gave ourselves the day for today. It was the court. And so we came, and the court itself said, move your application. If the application was granted, and we needed the chairperson of the Electoral Commission to respond, because it was leave that was sick, the court will now grant us leave. Then we will now go and file the interrogatory. It is what we have done that we can proceed. Without the benefit of the ruling, you said we should have come with the issue. If the interrogatories were granted, the net effect will be that the issue for trial will be narrow.
Yeah, I mean,
that is the essence of it. So how could that be coming to court?
Stay with me, Duji. Let me bring in Yababi Asamoah.
He will be coming to court.
He speaks for. He's a member of the. Of course, just a member of the spokespersons for the Nanado team. Speaks for that team. Duji, stay with me. Let me bring in Yababi. Mr. Asamoah, thank you for your time.
Thank you very much, sir.
I heard asserted by Frank Davis today that your belief that the John Mahama team did what it did today with the motion as part of almost a ploy to delay the process. But the court obviously entertained it because they believe it was fundamental and they had to rule on it. I wonder why you hold the view that there was a ploy to delay the process.
Thank you very much. We believe the NDC is not ready to proceed with the petition that they themselves have brought. And in particular, they're not ready to do the timelines that have been set out in CI 99. Because clearly, the application that was brought, which was filed yesterday, since 14th that we were in court, could have been filed much earlier, and yet it was filed only yesterday. The court thought it expeditious, necessary, that it heard the application, and that is how come it heard it today. But it took up the actual purpose of the court. Today was supposed to be case management, and yet because of that application, case management couldn't happen. So, and indeed, Mr. Chikata was asking for an adjournment to Thursday in order to find out his issues. And one realizes that these applications are designed to extend time within which the petition would be heard.
I wonder what benefit is it to the petitioners to delay this further? Isn't it in their interest to expedite this? And in fact, my understanding of interrogatories is that partly also helps in long run shortening the time you need to prosecute a whole case, because it narrows down the issues and it's easier then to deal with it. Isn't that one of the reasons why interrogatories are entertained?
Even two things in reaction to the question. One, the NDC is not in court for legal process alone. They are trying to find a way to emotionally bring down their supporters. They told their supporters they had won an election. It turns out they had not won that election. Nobody in there is bold enough to concede that they have lost this election, and therefore they are looking for a copycat way of letting themselves down gradually. And that is to model something along the lines of 2012, 2013. So it is not just about resolving the issues that the NDC is in court. They want to prolong this and make a show of it in public. That's the first thing. The second thing is, the court was very clear. Relevant. If the matters in the interrogatory are already before the court, why the insistence on having it rehashed in another application? And you have come to court with a petition that is clearly stating on the face of it that you are dealing with a number which you say, and therefore you have issues with that number. 35 paragraphs of your petition deal with the question of mathematics revolving around the 13.4 billion number that the Electoral Commission has already admitted was in error. You have been allowed to correct your errors, and you are still making errors, and the court accepts that you make those errors. And if you have brought a petition and it's been answered, and you are in a hurry to get it resolved, you can go ahead and then question the chair of the Electoral Commission in cross-examination. Because the questions you are bringing here are not in your pleadings. They are not in your pleadings. Are you trying to create pleadings through the back door?
Mr. Bobby, give me a second there, Mr. Bobby, on the point you just made. Let me bring me to the substance of what you put before the court today. Some of the questions, for example, question 3, is the 7 December 2020 presidential election the first time regional coalition centers have been interposed between constituency coalition centers and the headquarters of the first respondent? I wonder what the purpose, for example, of that question, because it is well known that this is the first time it happened.
Okay, so the essence of interrogatory, the law says this is it. You have filed your answer to the petition. In paragraph 5, you provided that you claim is how you complied with the law. The interrogatory is to elicit from you whether or not, in fact, same was done. That is what it is. That is how the interrogatories have the effect of narrowing down the issues. It's important, you see, when you were asking Malene Sita Wabin, regrettably, he decided to play mischief. If it's about expedition, the person he represents, Mr. Akufa, had over 8 months before our court to adjudicate on an election petition he brought in 2012. Was that for game? Was that for showmanship? Was that to provide comfort to MPP members? So when today an election petition is filed and we are going through the process required, it lies foul in the mouth of someone like Wabin, who has been part of an election petition before to insinuate that it is just a plot or a ploy to give comfort. Was that what happened in 2013 for 8 months? Please, let's speak to the issue than playing to the gallery.
And one of those issues is whether or not the questions you were asking could not have been dealt with in a cross-examination.
Incidentally, Mr. Akufo in 2013 had the benefit of the Supreme Court ruling favorably for him when he filed interrogatory. At the time when he did that, was it that Philip Patterson could not ask those questions from Afarijan during the cross-examination? What is he talking about? You cannot approbate and reprobate. You cannot, with the same mouth, double speak on the same issue. In 2013, when his lordship, Justice Badekwe, ruled on those interrogatories, was it the case that the lawyers for Mr. Akufo-Addo could not ask those questions under cross-examination? In any case, how in God's name would you want to sacrifice justice on the altar of extradition? Justice rush is no justice. Justice rush is no justice. And that is why candidate Akufo-Addo in 2013 had the benefit of 8 months to put his case across. We will not take this advice from Mr. Gwabin or anybody.
Mr. Babiasawa, so now that the court has delivered its ruling, the date has been set tomorrow for the case management to proceed. Your side is ready to go?
Evans, we are more than ready to go. But let's make it clear. This is not a copycat petition, unless that's what the NDC is choosing to do, which will then feed into showmanship. This is lessons learned. The Supreme Court, first of all, has a discretion to admit and grant leave for interrogatories, provided they are relevant. So the court, within its discretion, determined that these interrogatories could not be granted on the face of it because it couldn't establish relevance. It is in the jurisdiction of the court to do that, which they did. You can't argue, my good friend Eduji, that because it happened in 2013, automatically you must get it. Is that why Mr. Chikata went to the Supreme Court in the whole affair for a review, and he said the same reasons the Attorney General gave the last time, use those reasons for me too. We are going to do copycat litigation. So the court made 2 findings. One, an expression, it determined it was not relevant, particularly 2, in the context of the new rules, CI-9, which had been developed through lessons learned from 2013, 2014, 2012, 2013. It is this very same NDC, when they were losing election, who said that election petition hobbled them, and because of that, they couldn't work. 8 good months. To what end? So now, the law is clear. In 42 days, we cannot be chasing applications by the NDC. NDC has several more applications planned, all designed to prolong and extend.
Well, they've clearly stated that that is not their intention. But I'm grateful that you joined me, Yababi Asama. Thank you, Duji Tamaklo. Also, tomorrow we'll get to appreciate how this case will proceed until the 42nd day when it's designed to come to a close. Top story always brought to you by brought to you by Gas and Cement, Vodafone, and Belacqua Mineral Water. News Night in a minute.
55, 78, 58, 78. Hey, Charlie, my network is really